I'm with Giles Dixon, who's a construction lawyer, to talk about self-build projects and what are the contracts needed and what should they be like. So on a self-build project, which could be from an extension to an entire new home, why is it important to have contracts?
Well, assuming that you're not doing all the work yourself, you're going to have a contract with each of the people that you engage for the work, whether it's in writing or not. And frankly, you need it in writing. Building a home is quite an expensive exercise, and you need some certainty and a framework to deal with issues that arise during the course of the job, and that's why you need a written contract.
So who would the contracts be with?
Well, you will work out early on in the process how many people you're going to use or engage to do the work. You'll probably have, at the very least, an architect on any building project of any size, and he will prepare the drawings and the specification for you. And you may well, early on, get some indicative estimates from trade contractors or builders, and then work with them collaboratively before a formal contract is signed. An alternative would be to simply decide at some point whether you're going to have one main contractor who does almost all the work, or whether you're going to engage a number of different trade contractors for different aspects of the project.
And what will the contracts cover?
Well, the three main elements of a building contract are scope, cost, and time. What's the builder going to be doing for his money? How much is it going to cost you, and how long will it take? But there are quite a number of other issues as well that need to be covered.
You talk about the scope. How much detail should go into that, and does that go into the contract itself?
The more detailed the scope, the more certainty you will have in terms of both price and overall outcome. If you start with too little definition of what's required, there's going to be a danger that the cost could run out of control. So a fairly detailed scope is important. In fact, a very detailed scope is the best of all if you've got the time to do it, but there will always be some elements that won't have been fully scoped. For example, you won't necessarily have chosen your kitchen units at the time the contract starts, but that would have a provisional sum in the contract price, which would then be replaced by the actual cost when the time arrives.
And how do we cover pricing and payment in the contracts?
Well, the traditional method is to have a lump sum or fixed price for the contract, because that gives the client reasonable certainty, although sometimes it's said there's no such thing as a fixed price building contract. That isn't really true if the planning is done properly. But an alternative to a fixed price would, for example, be a cost plus formula where the contractor is paid for the labour costs and materials, etc., and then gets a fee or a percentage of the overall price on top for management and administration. And there are other formulas, but those are the two main ones. So far as payment is concerned, again, traditionally, the contractor is paid on a weekly or monthly basis against invoices which show what materials have been bought and what work has been done. An alternative to that would be a payment schedule. If, for example, you've got a project lasting 10 months, you might break it up into 10 separate units or break it up into a payment schedule which has milestones. For example, when the foundations have been completed, a payment is made. When the block work is done, another payment is made, and so on. But whichever method you use, the important thing is to try to avoid having the value of the work and the money paid to the contractor out of sync. There's always a risk if, for example, the contractor has received 90% of the money and only 2/3 of the work has been done, that your contractor could perhaps get a better job down the road with a wealthy banker and start laying people off to work there rather than finishing off your project. So, as I say, try to keep the two in sync, in balance as much as you can.
How about if I decide I want to change the layout during the project?
Your contract should have a change clause in it. Essentially, it will say that as client, you will tell the contractor the sort of change that you want. The contractor will then come back to you in writing with a proposal showing what the cost will be, or there might be a saving, and what the impact of the change will be on the programme and the completion date. And then, provided you reach agreement on that, it will be signed off in a change order or change confirmation form so that both parties have agreed on the extra cost and the extra time involved.
And what if we find, I don't know, Roman remains whilst the building work is going on?
Well, again, the contract should have a mechanism for dealing with this. Any unforeseen event which a contractor comes across may be grounds for delay and an extension of time for completion of the work. In the case of your Roman remains, the contractor should be contractually required to tell you right away once he finds the problem, and then you would work out with him what time extension should be allowed and whether or not there are any cost implications. I mean, some events, if they're foreseeable, for example, if you knew that there were likely to be Roman remains, then that should be factored into the contract price and the programme. But in the sort of case that you've given me, it may be that time would not be lost because the Roman remains are found by the east wing and the contractor can finish off working on the west wing while the antiquarians are sorting out the remains.
So what if I'm not happy with the proposed cost of the unforeseen changes, for example?
Well, if you can't agree, you can, assuming your contract allows you to, you can instruct the contractor to go ahead with a particular course of action, and he will comply, and any costs that he incurs, he will charge you either by reference to rates, daily rates that are in the contract, or else he'll get a fair price at the end of the day. But if there's a complete falling out and the contractor refuses to do what you want, then provided you've got a termination clause in the contract, which is quite important, you would be able to give notice to terminate, but hopefully that can be avoided. And in the meantime, of course, there will be, or there should be, a dispute resolution clause in the contract which allows one or other party to go to, probably to an adjudicator who will make a fairly quick decision on who should do what and how, or else mediation is quite common and a fairly cheap and quick option where each of the parties would sit down together with a mediator and try to reach agreement on the outcome. Because it's in everybody's interest at the end of the day to reach an agreement on these things, not to end up in court.
Well, let's hope our project would proceed nicely to the end. And what do we need to think about at that stage?
Well, the contractor will normally tell you when the work is ready. You and your project manager and probably the architect will go around the site. You will satisfy yourselves that the work is completed. You will check that all the electrical, mechanical and other installations are all been tested, and then a completion certificate will be issued to the contractor. And one of the implications of that is that the risk in the project then passes from the contractor to you as the client, because while the contractor is working on site, they'll normally have all risks insurance to cover the risks, and they'll be responsible, for example, for loss or theft of materials while on site. But once the contract is finished, it's over to you as the client. There will normally be a snagging list, items that still need to be dealt with but don't actually stop you from occupying the property, which have to be sorted out. And then most contracts will contain a defects liability clause, so that for maybe 6 or 12 months after completion, the contractor has an obligation to come back and fix any problems that are his responsibility.
So after they've gone, let's say in a few months' time, I get a leak in the roof. Do I have any rights or control over how that's dealt with?
Well, if the roof is leaking and it's the contractor's fault, the contractor has a duty to come back and fix it. And indeed, it's in his interest to do that, because it would probably be cheaper for your contractor to fix the problem than for you to engage somebody else and then send the bill to the contractor. Once the defects liability period is over, the contractor is still at risk to some extent, because what the law says is that for 6 years from completion of a project, a contractor would have liability for a defect for which that contractor is responsible. In the case of a building contract, the documents are quite often signed as deeds, which means that the limitation period, the 6-year period, is extended to 12 years. Now that, of course, can present problems because contracting businesses can go out of business. And so what I would certainly recommend any self-builder to contemplate is to take out some warranty insurance. You can buy a 10-year warranty policy which will cover those risks once the job has been finished.